Hello, my name is Joshua Gilliland, attorney blogger on Bowtie Law, and welcome to my special 400th Bowtie Law blog post. And yes, bow ties are cool. I have seen many amazing things since I started my blog. I've been all over North America. I have met fantastic attorneys who are dedicated to helping their clients. I've met phenomenal judges who take their jobs profoundly seriously, and it's fascinating to spend time with them, getting to talk to them, and hearing the challenges that they face from the bench. I've also had fun. I recall going to one conference and skipping the keynote so I could go see the second to last space shuttle launch. That was wicked awesome. I then was able to take my father back for the final launch, which was a lot of fun because he was in charge of putting the tiles on the Columbia. So it's amazing to spend time with judges and other attorneys and find out what's actually happening in the trenches and what they are experiencing on a day-to-day level, whether it is a Pinterest post getting somebody into trouble or an arraignment using an Instagram photo. Just fascinating things are happening out there. Now this video recording is going to focus on several big themes. The first big theme is for all the service providers out there. Now in the past year I've had the good fortune to go to one of the comic book conventions and to the Geeky Awards, and I've noticed that there's a couple big differences between other industry events like comic book conventions and an EDiscovery show. And it's not just the subject matter, which is fairly obviously different, but it's the energy. A lot of our shows don't have the passion that you would see at any other industry event. And I've been theorizing, how can we get excitement back into our profession at our events? One of my good friends highlighted the need for software companies to not be afraid to discuss their products. And not just to discuss their products, but actually how attorneys can use them in the practice of law. That dynamic of tying the practice of law to the software products is something we need to work on. Lawyers need to understand how you can use early case assessment to identify initial disclosures, or being able to validate search terms that are being discussed at a meet and confer, or how predictive coding can be used. Being able to bridge that gap is profoundly important. And the other part of that we need to look at is the subjects at the conferences. It would be fascinating, instead of having a conference that has 6 panel discussions on predictive coding, but to have, say, 1 or 2. Have a judicial panel, which is important, and then have the industry expert panel. Invite people from the big companies that actually make a predictive coding tool to talk about how they see the world and how they help attorneys and where they see technology going. Those are questions that we need to be asking, and people need to talk about that. They need to tie the world together on the practice of law and how you use the software to do it. I would also encourage every product marketing manager out there to spend an hour at your local courthouse watching the case management calendar. Do it both at the state courthouse and the federal courthouse and see what's going on and figure out, does the product that we make help these attorneys? Does it help these clients with their goals? And you have to figure out, what is that gap? Are we making this matter? Because when I talk to, say, state court judges here in Silicon Valley, they don't think about that stuff. We actually have mandated rules under the California Rules of Court to talk about e-discovery issues with preservation being first. And people don't do it. So that's one of the giant issues that we are facing, is that gap. But let's go back to the conferences for a moment. I'm not suggesting that we have people dress up as Philander Knox or Grover Cleveland at an e-discovery event, even though that would make things more interesting. But being able to tie everything together and to focus on the tools that we have and the future is something that we need to do more of. There's been some great efforts this past year, but it needs to go further. One of the greatest challenges we have in electronic discovery today are all the lawyers who want to practice law in the 1890s. We cannot turn back the clock on electronically stored information. How people live is what we end up having in discovery. It's a fact of life. It's the way it's always been. We cannot make text messages or e-discovery go away through threats, Pinkerton, or court orders, because we live in the present. And in every second of every day, the present turns into the future. We live in the age of electronically stored information, and there is simply no way of ignoring the E in e-discovery. Data can multiply like a tribble. Feed it 1 grain and it will keep growing, and you'll keep getting more and more tribbles. The same can be said for email and text messages and instant messages and Twitter posts. You gotta be on top of these things. E-discovery is a fact of life for attorneys. You literally cannot avoid it. There are lawyers who don't want to talk about iPhones, don't want to talk about social media, don't want to talk about the foreign production, don't want to talk about metadata, do the drive-by meet and confer, and then they wonder why things go sideways in a lawsuit. You have to acknowledge these problems. You have to study up, and you have to know who to call when you need help. Just because you do personal injury does not mean you will not have an e-discovery issue. Because if you had a client in a car crash, I will bet you somebody got out a cell phone and took pictures. Those photos could be extremely helpful because they were taken at the scene of the accident. They're going to be stamped with metadata that has GPS coordinates on them, and there might even be relevant video. You just don't know. Think of all the people who are riding motorcycles who have GoPro cameras on their helmets. That could be profoundly useful if they got hurt. You also have all the black boxes in cars now that send data back to insurance carriers. I'm surprised we haven't seen more requests for those in state court. So there's lots of information out there, and we are surrounded by it. You can't ignore it. There are many big legal issues that we have to address. One of the best cases that I read this year was AMC Tech v. Cisco. It's a Judge Graywall decision, and it deals with the scope of the duty to preserve and what to do when it's triggered. There's a brilliant opening line from the case that states, "With varying degrees of sophistication, most parties have gotten the basic message. The duty to preserve begins at least no later than the day they are sued and told about it. Less understood is exactly what a party must do and by when." It is a brilliant opinion. I did a blog post about it, and I encourage everyone to read this case because it is a brilliant case study on analyzing the scope of the duty to preserve. I look forward to the future of e-discovery. The technologies that people are working on are cool. They are helpful. You have software tools that are wonderful project management communication platforms, so you can see all the decisions that are being made, so they're not hiding in email inboxes, which is kind of problematic when you're trying to confirm whether or not hard drives were searched. So there's lots of good things out there. You also have a more mature industry at this point where people recognize the tools that are needed to help attorneys practice law. And it's moved to the left, and it's also moved to the right, because we got great trial presentation technology available as well. There will always be a need for attorneys, because when people are in trouble, that's who they look towards. There will always be a need for good judges. And so, while there are many challenges in the practice of law right now, I do remain optimistic, and I encourage everyone to look towards the future with high hopes.